Passage 19 start. Brief facts of the case are that petitioner plaintiff filed a suit for declaration to the effect that he, being bona fide purchaser of the suit property fully mentioned in the head note of the plaint, was entitled to claim its proprietary rights, and nobody, including the respondents, was justified to interfere with his possession. The said suit was contested by the respondents defendants by submitting their separate written statements. The respondents defendants number 1 to 3 filed an application under order 7 rule 11 of CPC for rejection of the plaint before the London Trial Court. The London Trial Court dismissed the said application wide order dated 10/2/2005. The respondents defendants number 1 to 3 preferred a revision petition against the said order, and the London Lower Revisional Court Additional District Judge Bhavannagar accepted the said revision petition wide order dated 21/9/2005. Hence, this writ petition, the London counsel for the petitioner has argued that both the orders passed by the two courts below are at variance, that the provisions of Order 7 Rule 11 of CPC did not apply in the instant case, and that it is a settled principle of law that court has only to examine the contents of the plaint at the time of deciding the application under Order 7 Rule 11 of CPC for rejection of the plaint, that the petitioner plaintiff, being the bona fide purchaser of the land, was entitled for the decree of declaration that the impugned order passed by the London Lower Revisional Court is illegal, ineffective, void ab initio, and is liable to be set aside. Conversely, the London counsel for the respondents defendants has supported the impugned order. He further argued that the disputed land stood cancelled from the name of the original allottee, and then the border area committee was competent to allot the said land in favor of any deserving personnel, and in this regard the jurisdiction of civil court has been specifically barred by the statute promulgated for the allotment of border area land. He further mooted that the civil court could not adjudicate the matter when the jurisdiction of the said court is specifically barred. Arguments had record perused. The perusal of the plaint reveals that the disputed property had been allotted to Subedar Kanwar Javed Ahmed, respondent defendant number 4, and Patta Malkiyat was also attested in his favor on 12/5/1980, which was followed by mutation number 24 dated 2/7/1981, duly sanctioned by the revenue officer in favor of the said respondent. Thereafter, the respondent defendant number 4 transferred the said disputed property to Mushtaq Ahmad, respondent defendant number 5, through registered sale deed number 194 dated 24/4/1985, and then the suit property was alienated in favor of the plaintiff petitioner wide mutation number 52 dated 18/3/1992. Now, on the strength of said transfer mutation number 52, the petitioner plaintiff is in occupation of disputed property as exclusive owner. The respondent defendant number 2, chairman border area committee, without notice and affording opportunity of hearing to the petitioner plaintiff, has cancelled the original allotment of defendant number 4 wide order dated 26/9/1998. The petitioner has challenged the said order and its implementation in the revenue record on the ground that the same is against law, without jurisdiction, ex parte, malified, and collusive, which is liable to be set aside. No doubt, respondents defendants number 1 to 3 contested the suit and thereafter filed an application for rejection of the plaint, which was dismissed by the London Trial Court wide his order dated 10/2/2005, but the London Lower Revisional Court has allowed the revision petition through the impugned order. Full stop and close.